Now, can you explain to us why he was denied in his first bail hearing and his second bail hearing? What were the reasons that the two different judges, I believe, denied him bail during those two hearings?
That's correct. I think you have to start with what a judge is looking at when we're talking about bail, right? And it's not just in this type of case that he's facing. It's the same thing whether we're talking about a federal case or a state case. The two primary things that a judge is looking at is number one, danger to the public, including danger to any alleged victims and danger to any potential witnesses, and then flight risk, right? And so the combination of a person's criminal history or lack thereof, their ties to the community, the seriousness of the allegations and charges, because unfortunately, well, depending on how you look at it, a lot of times for our clients, it's unfortunate that the judge has to accept as true the allegations that are put forth by the prosecutor. And so that can oftentimes be, you want to let your client know that beforehand, right? Because it can make for a very awkward and uncomfortable situation when the prosecutor is rattling off basically the facts of their case, which are coming from, the witness interviews. The police or federal agents in this case are going to have interviewed all their witnesses and collected evidence. And so the argument from the prosecutor is going to be a summary of all that, which is obviously going to be the basis of their case. And the judge has to take that as true, right? And so a lot of times, the facts of the case are going to be contested by the person who's accused, right? A case can be based on misidentification. It can be based on lies. It can be based on a misinterpretation of what ended up happening, right? But unfortunately, with that standard in place, so the judge has to take as true the allegations set forth by the prosecution. That's a difficult burden to ultimately overcome. And in this case, it's been shown that these judges took that that puff would basically be a safety risk, right? So the courts are always going to be concerned with, all right, if I let you out on bail, am I putting the public safety at risk, right? It was that in addition to the concern about witness tampering, right? So the prosecution alleged that he was repeatedly contacting alleged victims and witnesses in this case, basically in the months prior to him ultimately being arrested. And there was one in particular that I think was the most concerning because he had reached out numerous times. It looked like over 100 times him reaching out and saying, "Hey, I just want to offer my continued friendship and support, right? And that he would continue to pay her rent, if she played ball, right? And so, when it comes to witness tampering, which is basically trying to improperly influence or change or even prevent testimony from happening, and you could say he went about it in a very subtle way, not outright saying, "Yo, don't come to court or don't don't testify, against me." But and his lawyers, they're obviously advocating for their client, just saying, "Hey, these are people that he had a relationship, and he was just reaching out, letting them know that, hey, my lawyer might be reaching out to you." And that is, oftentimes something that will happen. When you're investigating a case, and somebody has a relationship, it can be a little intimidating to have just out of nowhere some private investigator reaching out to them. So sometimes your client might reach out like, "Hey, I might need you as a character witness. My investigator or my lawyers, my legal team might be reaching out to you. Just want to give you a heads up." And basically to answer that question, yes, his bail was before a magistrate judge, which is always going to be the initial judge that your that bail's going to be decided on. And then if it doesn't go your way, then you get that sort of second bite at the apple, putting it in front of the district judge, who's going to be the judge that presides over the motion hearings and the trials and everything. But basically on the same basis, the judge is denied, and it was somewhat surprising, right? I mean, you could see why they would rule it that way.
Okay, I want to ask you about the witness tampering. Wasn't all of those contacts made in the context of what he was going through civilly at that time? The criminal case hadn't been unsealed at that point, and does that does a judge or the court look at that a little bit different?
Well, I think that's the argument that could be made, right? I mean, there's a number of reasons why he could have been reaching out. There could have been the possibility of settlements, in terms of reaching out to these individuals, and letting them know that, hey, my legal team will be reaching out. If civil lawsuits had already been filed, because I just don't know all the people that he's alleged to have reached out to, but if these people weren't yet represented by counsel, or even if they were, I mean, a lawyer is not supposed to talk to somebody directly who's represented by counsel, but that doesn't exactly block him from doing so. I mean, the lawyer would probably advise their client not to reach out to somebody if there's pending litigation. You need to let the lawyers handle that. But there are a number of different reasons, and again, these are all people with whom he had a relationship, right? So these communications didn't necessarily have to be him, seeking to intimidate them out of testifying or influencing their testimony. And that's exactly what his defense is arguing, that there's no evidence whatsoever of him seeking to intimidate these people or trying to unduly influence their testimony. And that is an issue of fact for for the courts to decide. So obviously there's going to be both sides making their argument. Obviously the prosecution saying that it was witness tampering, and the defense saying that that there was nothing nefarious about his contact with any of these individuals.
Now, at this third bail hearing at the appellate court, does the prosecution have to prove to the judge of the intimidation? Because you said earlier that they could just make the allegations and the judge has to accept that as fact. Wouldn't they have to at least bring some evidence and proof of this intimidation, or they can just merely say he's intimidating and that's it?
So at the appellate court level, I believe that they're just reviewing the underlying decision. So there's not going to be new testimony and presentation of evidence. Typically, you're making your arguments based on the record that was already received by the magistrate judge and the district court judge. So the appellate court is just reviewing to see whether there was substantial error on the part of the magistrate and or the district court judge. So I think that what has already been submitted to the court will be the only evidence that that is accepted. So both sides are able to argue their positions in terms of what the what the evidence means. But to your point, in terms of what the lower judges would have been considering, the allegations set forth by the prosecution, unfortunately, are accepted as true. If the defense, if the defense has in some sort of argument, which it sounds like they made, that these communications were, again, that there was nothing nefarious or nothing suspicious or anything like that about these communications, then it'll ultimately be the appellate court reviewing what the magistrate and district court judges ruled on, and then saying, okay, well, did you guys commit some sort of error in assuming as true that this witness tampering had actually occurred, or that you ultimately found that Mr. Combs would be a danger to the community or to the public at large if he were released. So they're reviewing the magistrate and the district court judges for substantial error versus now accepting brand new evidence and the like.
So in your experience, how is this going to end up in this third hearing? Because he's not charged with murder. He's not charged with a capital offense. The charges that he's facing are normally you get bail on these types of charges. How do you see this playing out in this third hearing? And is this third hearing will be the final hearing regarding bail?
Right. And so it's, it's a difficult uphill battle, right? So if we're looking at a balance of the scales, it's definitely tipping in favor of the prosecution and keeping him detained throughout the rest of this trial, or throughout the rest of these proceedings, until he has his trial.
Isn't that a
Because of
violation?
that,
Wouldn't that be a violation of his constitutional right though to get bail?
yeah, and so that's definitely part of the argument that will be made by the defense, because liberty is supposed to be the norm, right? Liberty is the norm. He enjoys the presumption of innocence. He is absolutely innocent unless and until he is proved guilty or he admits guilt. And to the contrary, his attorneys have come out and said that he's innocent, and it's not even just that. Sometimes, and this is where the subtleties of language need to be paid attention to. His lawyers aren't saying, well, our client is presumed innocent. He enjoys the presumption of innocence. No, they're coming out and saying that he is innocent, that he has done nothing wrong in this situation. It appears that the defense is surrounded around basically that everything that went on is consensual, right? And you may not agree with Puff and his crew's lifestyle, right? It may not be something that us church folk would support, right? But there's nothing illegal from their perspective. There's nothing illegal about having these type of parties and drugs being involved, alcohol being involved. And just this mix of sex. We've heard the word freak off I don't know how many times, but there's nothing illegal about this, and everybody was a willing participant, right? And when we look at the standard, which is generally that liberty is supposed to be the primary standard, and being detained is not supposed to be a function of a pre-imposed penalty, right? It's only supposed to go to those concerns that we discussed earlier. And so with them putting together that package, the judge, they're supposed to find, if they can find that there's less restrictive conditions or combination of conditions that will that support protecting the public and making sure that he's there. The defense is going to say that yes, this is a violation of our constitution, our client's constitutional rights. We've committed to putting up $50 million, and all these other conditions. That certainly would be enough to address the court's concerns and for them to continue to hold in custody a man with no criminal histories. For them to continue to hold him in custody like this is absolutely a violation of his constitutional rights.
Wow, that's crazy. I want to give my co-hosts an opportunity to ask you any questions if they have any. Munchie B or Spider Loc. We got criminal defense attorney Jamahl Kersey from San Diego.
How's it going, Jamahl?
All is well. All is well. I'm blessed, brother. How you?
I'm good. Okay, so you knocked out two of my questions because I was gonna ask how common is it, but before they set a bill, you come with a bill package, but you answered that because Young Thug did the same thing. I never heard of that, and then you they already presume that the prosecution is coming with the truth versus like the burden of proof is on the prosecution. So it seemed like it's the opposite in this case. And then I wonder why did he have to offer his kids passports being coughed up because of his case? Why
Yeah,
did
and oh,
go ahead.
go ahead. Sorry.
Go ahead. I'm listening.
No, what I was going to say is it's not really common to have this level of a bail package put together, right? We've heard about it recently because of Young Thug's case. I mean, he had Kevin Liles, testify, right? Obviously, he has I think it's 300 Entertainment. That's a big wig to have come through and testify at your bail hearing, right? And then had a private security detail come in and testify, and trust me, that would not be cheap, right? To have 24/7 round the clock security detail at your house to make sure that nobody comes in and that he doesn't leave and the like. And so obviously these are two gentlemen that have substantial resources, and you're really going to do everything that you can. You're going to do everything that you can, leveraging your resources to to try and appease the judge, to try and convince the judge, hey, listen, I'm not going anywhere. I'm definitely willing to participate in this process. I have no criminal history. I'm going to show up to court. I'm not going to intimidate any witnesses. I'm not going to, I'm not going to harm anybody. So really, they threw everything that they could at it, but unfortunately, just and again, the allegations are serious, and one thing that I hadn't mentioned is the court also takes into consideration the amount of time that a person is potentially facing, and so the prosecution hasn't exactly come out and said what his exposure is, but just based on the nature of the charges and everything, he's probably facing decades in prison, right? And so for him at 54, I believe, if he's doing 20 plus years, 30 years, that's essentially a life sentence.
Yeah, that's
and
a
so,
life sentence for sure.
that's difficult to overcome.
Okay, and then they say witness tampering and witness intimidation. What's the difference? Is it a difference?
Well, I mean, you could tamper without intimidating, right? So that would be the difference. I think witness intimidation could probably fall under the umbrella of witness tampering, right? Because in this situation, he was saying, "Hey, I'm just at least this is what the allegation from the prosecution is. I'm just looking for your ongoing friendship and support, right? Just you continue to keep it cool with me, I'll keep it cool with you, right? I'll continue to pay your rent, right? So there's nothing really intimidating about that. On the contrary, that's a nice little setup, right?
That's like subtle intimidation, right?
Yeah. Well, not. I mean, not
It's
really,
not
right? You
intimidation
just
at all, though.
you just continue to help me out, and I'll keep paying your rent. Like, there's nothing really intimidating about that. That's a nice little hustle for somebody if they're down to do that, right? Okay, well, I got you. I'm either not gonna work with the law enforcement, or I'll say whatever it is that you want me to say. You keep paying my rent. So but on the other side, there has been allegations in terms of actual intimidation, and so that's where you have certain things in your past that get dug up, right? We had that whole thing with what was it, with Kid Cudi and blowing up his car. Yeah, actually that's part of the allegations in the indictment, right?
Right.
All the collective things that you've been engaged in, whether it's actually part of the charges or not, they take all that into consideration, and you certainly don't garner any favor in front of a judge when you have part of your allegations that you blew up somebody's car because they were trying to date your girl, right? So it's a
crazy.
difficult. Yeah, it's definitely a difficult situation for Puff on the issue of bail.
I kind of got two questions too. You guys keep bringing up the young trial case as a comparison on the bail situation, and I'm not sure of your knowledge of the R. Kelly situation, but I wanted to ask you: is Diddy's situation more like R. Kelly's, or is it more like Young Thug's? And if you recall, did R. Kelly receive bail at this juncture in his case? And my other question was, I forgot about the car, but I wanted to ask you if you thought that the Cassie video is perhaps prejudicing the judge against bail.
Yeah, man, this Spider Loc.
Yes, sir. Yes, sir. What it do, Brody?
Oh man, that's a trip, man. All right.
My
Nah,
nigga.
man, I was just listening to the which mixtape was it? I was just listening to the G Unit Back to Business mixtape.
Okay, that's
He was on
hard.
That's amazing. We got a
That's
criminal
new,
defense
Brody.
attorney tapping in with some Spider Loc music, huh?
That's
Hey
hard.
man, hey man, I'm hip hop to my core, man.
That's
But
right.
yeah, man. Yo, that's dope. That's cool. No, so when it comes to the R. Kelly situation, we definitely have, and to your point, that's a good question. It's definitely closer to the R. Kelly case than it is to the Young Thug case. In that we have the allegations of a prominent music figure having a legitimate business, and actually, I mean, I guess on that note, Young Thug, same thing, right?
Mhm.
Young stoner life
Right.
versus young slime life, and having a record label. And hey, nah, like this, like we're not gangsters. We have a legitimate record label. We sell millions of records. This is a multi-million-dollar business. We employ a lot of people. this is completely legit, which is what Kevin Lau's testimony was. Like what are we even talking about here? Young Thug is an artist, right? He doesn't have anything to do with, obviously he comes from an environment, but he's since left that life, and he doesn't have anything to do with this. And so, but because it's of a sexual nature, right? When we're talking about people being forced to do things that they didn't want to do, then that's where it becomes more, parallel and analogous to R. Kelly's situation, where they're alleged to have leveraged those that power, right? That enterprise, that business structure, and yes, these are record labels and executives, but being able to use that in order to coordinate travel, in order to coordinate lodging, in order to coordinate the recruitment, in order to coordinate payments or all these different types of things, just things that would be beyond the scope of one individual's ability to do. And to your other question about that video, yeah, I mean, both, I would say both probably in the courts and in the court of public opinion, that's so powerful. And I certainly don't want to minimize what that situation was, but domestic violence cases are what our firm primarily handles, and it kind of is a run of the mill domestic violence case. It's certainly not the again, you kind of have to tread these waters carefully and with all due respect. But it's not the crime of the century. It just happened to be caught on tape, whereas most domestic violence situations are not, right? And so there are a couple ways that this has affected the defense's credibility, in that when Cassie had come out with these allegations, there was a lot of talk, I think, both from Puff and his legal team and his camp, that, oh man, this is just a money grab. This is BS. Justice is going to be served. The truth is going to come out to light. None of this stuff happened. And then boom, that video drops. And now you gotta backpedal, and now you're doing the most ill-advised thing in the world, which was sit up in that BS apology video.
That was
you just out here looking crazy. Yeah. No, there's no lawyer on this planet that would be like, yo, Puff, that's a good idea. Right?
It's so difficult to reflect on the darkest times in your life. But sometimes you got to do that. I was up. I mean, I hit rock bottom. But I make no excuses. My behavior on that video is inexcusable. I take full responsibility for my actions in that video. I'm disgusted. I was disgusted then when I did it. I'm disgusted now. I went and I sought out professional help. I had to go into therapy and go into rehab. Had to ask God for his mercy and grace. I'm so sorry. But I'm committed to be a better man each and every day. I'm not asking for forgiveness. I'm truly sorry.
But my homie has obviously been asking me like, yo, could you take on a case like this? And I just think like, from what I see, like he might not be the easiest person to work with. And when you have somebody that powerful, right? Because we've seen at all kinds of different turns where you have steps and actions taken that no attorney would ever advise you to do, right? But when you're sitting on $1 billion, and that may not, that's obviously not liquid cash, but when you're sitting on $1 billion net worth and you're at that level, and we've seen some of them videos, right? Like, I'm a savage, right?
When the soundtrack comes out, if so, bump somebody. All right, thanks. All right, love you, man. Bye. I got my MTV out. Savage! I'm a savage! Oh! I'm a savage! Whatever I want, I'm going to get! Whatever I want, I have to get!
It's so damning now. Yeah.
When you're at that level, it can be there's only a handful of people that have your ear, and attorneys, you know, for all their education and experience, may not be amongst that group of people, right? And so, but what that video did was, you know, obviously it's disgusting, you know, that it happened in and of itself, but then also for it to just be replaying over and over. But for you to deny that happened and then have to backtrack and make an apology, I think it just goes to, you know, some of the credibility from Puff and the lawyers has been damaged by that.
It sounds as if P Diddy has a challenge in this third hearing for his bail. I want to thank you for tapping in.
Hold on, one more
with the
question.
Straight Politicking podcast. Go ahead, Munch.
All right, because I heard something over this time he been locked up. Do the federal system supersede any NDA you got in place?
That's a good question. So I assume you're talking about like with some of these civil cases and everything, right?
Mm.
Right. So if people have signed agreements not to testify, that's a good question.
No, I'm talking about not to speak on what's going on inside the homes or like the chefs or females. They sign NDAs. What's going on in my personal life? So that's no bueno once it comes to the feds.
Well, yeah, I mean, I that's a good question. I don't know if the prosecution will be able to get around that. You know, if they already have legal agreements that are signed, right? You know, there could be some sort of argument that that these people were intimidated into signing these things. So I think like if the NDA were to otherwise be some sort of bar to them testifying, then I could see, you know, just based on the allegations, the prosecution trying to make the argument that these aren't even legitimate non-disclosure agreements because of the manner in which that, you know, their signatures were obtained.
Okay.
All right, man. Jamahl Kersey. I know people can find you at Jamahl Kersey, and your name is spelled JAMAAHL Kersey on Instagram and YouTube. And,
That's right.
And people could also tap in on your legal website, Kersey Law. Is that correct? KerseyLaw.com.
It's a KerseyLawOffice.com.
I'm sorry. Yeah, KerseyLawOffice.com.